Welcome to the Africa Speaking Podcast. The podcast discusses critical issues about the African continent. It is brought to you by Toyeza Communications in Nairobi. My name is Kimani Njogu. Thank you again for accepting to talk with me in this Africa Speaking Podcast. So, in our last conversation, Chief Justice Mutunga, we discussed radical Pan-Africanism. But today I would like to discuss with you about constitution making in Kenya. You have been at the center of constitution making in Kenya in your various roles within civil society and the judiciary. Could you kindly sketch for me the journey that you have walked in the constitution making process?
I think the journey begins even before I joined the University of Nairobi as a lecturer. I was aware that immediately after independence, as the change amendments were being made, there were voices that basically said, this wasn't independence. It was a capitulation. Of course, they didn't use the word neocolonialism, but the intellectuals did. Or basically saying this constitution is a pact that continues our domination and lack of freedom, etc. And there was, during those periods, of course, a lot of underground leaflets and pamphlets. And one I remember reading in the 60s was Munguzi. It was done by people like Mochi Washira and others.
Yes.
And it was a call for a new constitution. They were basically saying the independence constitution was just a sellout. And
so which period is this? In the 19...
So it's late 60s.
Late 60s,
yeah.
Great.
Because I'm...
Before you went to the University of Dar es Salaam.
Right, before I went there. Mm-hmm. Because I went to the University of Dar es Salaam in 68. But at Strathmore, of course, we were followers and members of Kenya People's Union.
Correct.
And they were talking about these issues as well. A new constitution, their position, that is Kagia's, Odinga's, and P.O. Gama Pinto, their position on land was clear. If you look at the KPU manifesto, there were 90 declarations, as they called it. It has all those details about the constitution, how the economy is to be managed, and the fact that we shouldn't have accepted the willing buyer, willing seller, nonsense of the independence constitution. Because you remember even is Nyerere who laughed at it and says, this willing buyer, willing seller is interesting. Ni kama mtu anakuibia koti, kisha analiweka na baadaye anakuja na kuambia koti lako sasa ni lakini lipe. So it's the same thing, you've taken my coat, you've stolen my coat, and you tell me to pay to get it back. And the idea here was that the British did not buy that land, they stole it. Okay? Even against their own laws.
Absolutely. Where
thieves don't pass title. All right? They used all manner of things, obviously doctrines in international law, to legitimize the theft. But we can't imagine if the Mau Mau War had succeeded, the British selling land to anybody. They were going to be evicted by those forces from
going to be taken.
Yeah.
And that was also the period that, you're right. I think there were all these leaflets. That's when Abdulatif Abdallah, for example, was, Kenya to end up.
Yeah.
So there was all these very active activities questioning the direction that Kenya was taking in the 60s.
Yeah. And when I get to the university then, and we come up with December 12th movement, it was called December 12th movement to signal that it started at the eve of independence.
There was no break.
There is no break. It's this, what Rodney keeps on calling links and continuities.
Walter Rodney, How Europe Underdeveloped Africa.
Yes. You see, all these scholars and activists, even before we get to KPU, they were talking about these issues. And I remember being in December 12th movement, and when Pambana was, the first issue was written, the discussion around why December 12 movement is that continued. So basically saying the struggles for land and freedom did not stop with the Constitution, and they continued. And then, of course, that was also borrowed from KPU, with their very, very, very radical, manifesto.
The Kenya People's Union.
Yes, Kenya People's Union. And you definitely find parts of that in Kenya as well.
And also Mpatanishi, I think some of the
Mpatanishi writings, those was Kenya. And when they go to London, akina Yusufu, akina Wangui Wagoro, Ngugi, the Constitution was always seen as a pathway to discussions of transformation and change. And within the University Staff Union, as we called it, because we included the staff and students, that issue of constitution making was there, because, as you understand, the way even the independence constitution was mutilated from the word go, which is something, by the way, Githu, in his new book, which was his doctoral thesis, Constitution, Politics and Society, I think he covers all those amendments. So you have a government that is actually coming up with amendments to consolidate the dictatorship of the executive. But at the same time, people are still calling for constitution, so that the constitution becomes a form or a strategy for resistance. So I participated in the DTM. Kenya happened when I was, in prison. So when I came out, it's actually human rights now,
Because that's when you're now forming the Kenya Human Rights Commission.
Yeah. But before I was detained, I was working with Kituo cha Sheria. We were giving legal aid and legal advice for free. It started in Shauri Moyo, but I didn't go there myself. I went to Isli Community Center, where we had an office. So Kituo is the oldest.
And you are focused very much on workers' rights, right?
Yes.
Yeah.
That's why we went to Isli Community Center, so that the workers can come in. And when I was interrogated by the police, they were asking me, why are you in the, working class areas and not charging? Which law doesn't charge for legal fees and so forth?
They had never heard of the pro bono.
No, they hadn't heard of it. So I came in from detention and rejoined Kituo cha Sheria with Muta Sajafa, the late David Kachuki, Jane Weru, and Gilbert Mungu. And we basically, continued. And the question of constitution making was never disengaged. And then you see the so-called second liberation of courses and the repeal of Section 2A was now a political movement that basically said the constitution has to be changed. They targeted 2A so that there could be multipartism. But when that happened, when 2A was, repealed, then they basically said, no, that's not enough. This entire constitution needs an overhaul.
Yeah.
That was basically the continuation, and that's how we got into NCC as part of it with political parties, and ended up with the IPPG, minimal reforms. Although at that time, a lot of young people were saying, we don't want minimal, we want comprehensive. Yeah, so there was that bit which we lost out when the political parties joined the IPPG and NCC. NCA became extremely weak. There was a discussion whether we could start our own, movement and party after that, but there was no conclusion for it. And so minimal reforms, but almost immediately in 1998, the debate for comprehensive, constitutional reform happened.
It picked up.
It picked up. And you have these two routes, the parliamentary route, and the one of Fungamano, which Dr. Mbaka was chair of. Then 2003, Yash Guy comes and
now picks the CKRC.
CKRC, and brings those particular ones. But, to just to finalize the sketch, after the NAC government.
There's the National Rainbow Coalition.
Yes, when they came in.
2002.
Yes. When they came in, they couldn't avoid the constitutional project. And that's how they got Guy in 2003 to come and start. And of course, I was member of the
Bombers Conference, which then came up with what we are calling the Bombers Draft. And so
I was, member of that, 408, I remember.
That was your number?
Yes, that was my number, because you had to lift.
Correct.
And say number 408.
Be given space to speak.
Yeah, but it's during that time, of course, at 2004. I joined the foundation.
The Ford Foundation,
the civil society. But within the Ford Foundation, of course, a lot of resources went into constitution making, human rights, civil society activities, and so forth, during that period. So I was too engaged. Going to the judiciary, the reason why I applied was there was the 2010 Constitution. And I thought, why not, go to the apex court and see what the judiciary what we could do, because it was very, very clear that, the judiciary was going to be pivotal in the implementation of that progressive constitution. Yeah. And after that, I've been involved in issues of implementation, because constitution making doesn't end with that document. It continues with the implementation and
constant reflection on it and so on.
Yeah. So my participation has been basically in writings, but also talking to a lot of groups, human rights, social justice groups that are interested in this issue. And of course, a member of Katiba Institute, which is doing a lot of work in terms of public interest litigation. Yeah. So that would be, a brief sketch of it.
Having known you now for close to 50 years, I have seen the journey, and I know you've been very, very consistent with this work. And I want to take you back a little, because you have mentioned some really key areas. And one of the things you have mentioned is that the constitution making does not end with the document itself. And I think that takes us now to the whole question of the distinction between the constitution and constitutionalism itself.
Yes.
If you could just create that distinction.
The constitution is... people tend to look at it as the legal document.
Yes.
The document that is legal-centric. And that is now the charter, which is basically the pact itself. And it's very abstract, because there are certain things, it's giving you a vision that you will have a democratic state, you will have this and the other, the elections will be free and fair, and so forth. I think constitutionalism is the late Okoth, because he wrote a brilliant piece called Constitution Without Constitutionalism.
Yes.
Okay.
An amazing piece.
Yeah, and he was looking at exactly what you are saying. The implementation is breathing life into what is a legal-centric document, and which is abstract. So the values that are in the Constitution, the implementation, the struggles between the implementation and where there is a resistance to implementation, which is our history now, and we see it very clearly. That particular, struggle, you can say, is a struggle towards constitutionalism. So that these values we have decreed in the Constitution become a reality. It's like if you take, for example, the issue of the vision in the Constitution of a democratic, secular state and society. Okay?
Yeah.
It's still being fought in court, and it's still being fought outside court, so that we can accept that vision. It hasn't been accepted because there are still, what we see, still divisions between the religions, and within the religions there are sects that are, also fighting. And so the coexistence is not there. And Article 8 said that there is no state religion. The whole constitution vision is that of secularism.
Secular state.
So that the devil worshippers, the traditional ones, atheists, humanists, the secularism is called, all those. Okay? And actually, when you look at the constitution, that probably is the best vision. If we implement it, that we can hand over to the world, which I haven't seen any other constitution that deals with that issue of diversity.
Yeah.
And you see it in the preamble saying we have a religious diversity, cultural and ethnic, but we say that's our strength. So it's the same vision, and constitutionalism, of course, is that terrain of struggle to achieve a particular goal. And as we have found out, of course, it's the fundamental factor in moving towards constitutionalism is the ruling class that is implementing the constitution.
So constitutionalism is behavioral.
Yeah.
It's giving life
Yes.
to the spirit
Yes.
of the constitution itself.
Yeah.
And it's also commitment of duty bearers,
Yes.
institutions, and so on to do whatever they...
And radical reforms in areas that guarantee, like if it's, say, Article 43 of the Constitution on socio-economic and cultural rights. You need resources, you need to deal with the issue of land, you need to deal with universal health care, education, and so forth.
So political power becomes important then. Like who is sitting in the executive to determine the ways in which the breathing of life becomes possible.
That's right. And that's why in the case of Kenya, we say, we have a great constitution, a beautiful baby, but we have given it to child traffickers. So, which now takes me, and we will get into this conversation, which then shows the ways in which constitutions are actually also political documents, as it were. Yeah, you're right. Although the lawyers don't see this, quickly, a constitution is a legal, political, and ideological document. That's why it becomes a site of struggle.
Yes.
Because when you go to how the Constitution is interpreted, the courts now have realized that you cannot leave what lawyers used to call the non-legal phenomena, including politics, theology, science, sociology, economics. When you look at the Kenya Constitution, it actually encompasses all those. When we did the case on digital migration, I didn't know what a spectrum was. We had to get scientists and people to come and tell you.
The experts.
Yes. So the Constitution.
So the judges get educated by the professionals.
By professionals who will tell you this is what it means, and and so forth. And that's why these constitutions, when they are called transformative, is to basically say they move from what the lawyers call legal positivism, where you just say the law is a law is a law. You don't want to be told, well, what about the politics of it? What about theological arguments? Now you have God in the Constitution. What about the economics? You were talking about land and how they should be. The vision of land is that we ultimately have access to land for all Kenyans when you look at the Constitution. But it sees what I might call the minefields, which is private property, Article 40. And how do they mitigate this? They say very clearly, okay, foreigners will not have freehold. And those who are freehold, we can always compulsorily acquire it and pay compensation. And then there's that beautiful Article 68. Going forward, we are going to have minimum and maximum acreage of land. And, of course, the National Land Commission, which is going to hold the lands that were grabbed, once they come back, they don't come back to the state. Article 61, I think, which says very clearly that land in Kenya belongs to Kenyans as a nation, and as individuals, and then communities. So there are those, categorization. And you can see the vision.
That is very interesting. I mean, I recall, the idea of maximum land ownership there was an attempt to introduce legislation in the 1970s by Koigi wa Mwere.
Yes.
In which he had actually proposed, and I think I recall that bill that the maximum acreage by an individual ought to be about 500 acres. I remember something vaguely like that. So I find it quite interesting that this idea.
It's actually 68. There was some MP who was talking about it without obviously reading the Constitution. Saying he's going to table a bill about maximum acreage. It's there and actually it's Parliament that is supposed to debate it. Okay, and once they debate it, they will debate it, of course, with robust public participation. It's a big thing, and it's a great example of a site of struggle, because the landowners, even if we tell them we'll pay you just and, adequate compensation,
they don't want to let go. In fact, my view has always been that you cannot discuss the Kenyan political trajectory without reference to the struggles of a land.
You can't, because it's tied up with the resources.
Absolutely.
And, even in terms of food.
Basic survival.
Those who don't even have an acre of land have an issue. But I think the Constitution understood that and took the incremental strategy. But if you had a radical political leadership, okay, you can actually
accelerate the process.
Yes, because why are people having 500,000 hectares and they don't use all of it? Okay, and we know which families have it. Why are multinationals, who actually got that land for free? So those issues are coming up, like the case in the European Court of Human Rights, where the Talai and the Kipsigis are suing for reparations.
The Talai, of course, having been moved from Uasin-Gishu to Kericho and all that, and their land taken. Actually, even to Kisumu, they were being moved to create space for...
You're absolutely right. The Mau Mau did not call their army land and freedom for nothing.
They knew what they were talking about.
They knew what they were talking about.
Absolutely. It seems then that constitutions and the idea of organizing society almost innate, almost like natural. So Kenya becomes a colony in 1920. And of course, then we are subjected to the British way of interpreting, the state and so on. And Kenya then becomes as a Kenya colony. Kenyan communities had constitutions before the British occupation of our country, isn't it?
Yeah, they had. Just like the British don't have a written constitution, but they have what you might call unwritten constitution. So if I give you my example of my community in the 50s under colonialism, there was that parallel development. The elders were there, discussions about grazing, about watering holes, and how disputes were to be resolved and so forth. How you dealt with the bringing up of children, how you shared community, resources. Because in the 50s, land in Kitui hadn't been titled. It wasn't a commodity. It was community land. And so there were obviously disputes about cattle trespass and whatnot. But the community said that. I always say that there was never a vacuum. And the British, of course, got into us through the native courts. And some people will go there on issues of dowry where they couldn't agree and so forth. But growing up in Kitui, a lot of disputes were settled through the Kidhitu oath. The people didn't go to any court. They would just say, okay, if you can't agree, then let's settle this by
oathing.
Yes, and that was, it's if they were writing a constitution.
Absolutely.
In terms of, the courts, instead of the jurisprudence, the Supreme Court will be the Kidhitu.
Absolutely.
End of it.
Absolutely. Yeah. And what is interesting for me then is the coexistence, plural coexistence, of the so-called formal. In quotes,
Yeah,
and the so-called informal in quotes.
Yeah,
because they are also institutionalized. Even the so-called informal are actually institutionalized. They have a system.
Actually, that's a brilliant point. I don't know why the so-called informal is not called formal, because it's the one that is accessible to 95% of the people. The other one is 5.
Absolutely. And we will revisit that question on how the so-called informal institutions make their way into the Kenyan Constitution.
Yes.
Because I think that was absolutely innovative. I think it was very considerate of our communities.
Yes.
And again puts the supremacy of the people at the center of our Constitution.
That's right.
Yeah.
That's right.
This concludes our first episode in our 3-part series of this podcast about constitution making in Kenya with Chief Justice Professor Willy Mutunga, President of the Supreme Court of Kenya. Thank you for listening to the Africa Speaking Podcast. Join us in our next episode, brought to you by Twaweza Communications. My name is Kimani Njogu. For any comments and views, you can reach us through our website, www.africaspeaking.org. You can also reach us on Facebook, Twaweza Communications, or on our Twitter handle @TwawezaComs. You can also write to us on email info@africaspeaking.org.